Okay, now we have discussed the Article 13 Clause 2. Now we will move further. Now what happens? Government was trying to bring the land reforms laws, and what types of land reforms government was taking to bring? They have to implement the land ceding laws. They have to redistribute the land holdings, and they were also planning to abolish the zamindari system that was prevalent during the colonial period of British history. Now what happened? What government do? Government brings the first constitutional amendment act. What government do? Government brings the first constitutional amendment act. And what is the first constitutional amendment act? This first constitutional amendment act had amended the various articles of the Part 3. Now what articles this amendment act had amended, we will discuss. Now this article had amended Article 15, Article 19 and Article 31. Okay, now we will discuss it separately. What amendments this, but to it introduced Article 15 Clause 4. By this amendment that Article 15 Clause 4 introduced, what it states that? It states that state can make any provision, state can make any provision, state can make any provision for the advancement of socially and educationally, for the advancement of socially and educationally backward classes, for the backward classes, which later became the basis of the implementation of the reservation, which we will discuss separate when we will discuss the fundamental rights. That this clause became the basis of the reservation. So this was brought by the first constitutional amendment act. Now what also it amended? It amended in the Article 19 Clause 2. In the Article 19 Clause 2, what is Article 19 Clause 2? The Article 19 Clause 2 basically contains some grounds on which the government can restrict the freedom of speech and expression. So these grounds are already mentioned in the Indian Constitution. So two more grounds were added in this clause. These two grounds which were added is public order and friendly relation with foreign countries. Friendly relation with foreign countries. Friendly relation with foreign countries. So this was added by the first Constitutional Amendment Act in Article 19 Clause 2. And the most important part which was added by the first Constitutional Amendment Act, that was main focus, because by this part the government was trying to bring the land reforms. So what is it introduced? Article 31A and Article 31B. These both articles you have to understand very cautiously and listen very carefully, because these articles always create confusion in the minds of the students. Because the 31A, B, C, these all are something which create the confusion in the mind of the student. So you have to understand very clearly these articles. What were these articles? So both were introduced by the first Constitutional Amendment Act. If the question comes कि 31A, 31B, when they were brought, so these were brought by the first Constitutional Amendment Act. What is the 31A? So the 31A clearly mentions the 5 grounds. This Article 31A clearly mentions the 5 grounds on which the government can bring the law. So these are the 5 grounds. If government can bring the law to achieve the objective of these 5 grounds, then this law cannot be challenged in the court of law. It means government had made the immunity to the lodge if they will achieve the objective of these 5 grounds. What were the objective of these 5 grounds? It is not much important, but I will give you a little bit overview. These were the acquisition of estate and property. The next one is management of property. Management of property. These are not much important. Management of property. Third one is amalgamation of corporation. Amalgamation of corporation. What is amalgamation of corporation? The amalgamation means if 3 or 4 industries come together and become one major industry. That is called the amalgamation of the corporation. So it was the doubt on the mind of government that the few industries can come together and monopolize any sector. Then it will be the against the interest of the consumers, of the mass public. So government has also mentioned that for to achieve the amalgamation of corporation, to bring the law against the amalgamation of corporation, then that law cannot be challenged on the ground of violation of the fundamental rights. Then the fourth one is the extinguishment and modification of the shareholders of a corporate. If the government is bringing the law which will extinguish or modify the interest of the share in any corporates, government can amend the shareholding of the proprietors or the shareholders of any corporate, then that law cannot be challenged on the ground of violation of fundamental rights. And the fifth one is the extinguishment or modification of mining lease, because this was the time when the few industries were only present. So these industries have given the allocation of the rights of extracting the minerals and to perform the mining. So government can take any law, bring any law to extinguish or modify the time period of mining lease. Okay, so these were the 5 grounds on which government can bring the law. So that law will be outside the purview of judicial scrutiny. So these were the 5 grounds mentioned in the Article 31A. Now, what was the Article 31B? So the Article 31 it clearly mentions the 5 grounds. There is no 6th ground. Clearly mentions the 5 grounds. But Article 31B is more wider. Why it is more wider? Because it states that any law means there is no constraint on the Article 31B. There are no grounds mentioned here. Here, these were the 5 grounds on which government have to bring the law. If government goes beyond these objectives, then that law may be challenged. But here, in the 31B, the parliament has amended and looked like any law which can put in the Schedule 9. The Schedule 9 had been introduced by the 31B. By the first constitutional amendment act, to any law which put in the Schedule 9. If any law which has been put in the Schedule 9, then it cannot be challenged. It means it is outside the purview of the court of law. So it means that Article 31B is very wider and deeper than the Article 31A, because it has given the government a large or blanket immunity to bring the land reform laws. Because if the government put in the Schedule 9, then it will be outside the purview of the Supreme Court. Then these amendments were brought by the first Constitutional Amendment Act. Now what happens? Now what happens if government has amended the fundamental rights in that way, then people will not listen carefully. People have to react. Then how will the people react? Then they challenged this first constitutional amendment. The first constitutional amendment act has been challenged. Because why it has been challenged? Because the Article 13 clause 2 clearly states that, categorically states that, if the state shall make any law that takes away or abridges the rights conferred by the Part 3, then that law will be unconstitutional or null and void. So now the first constitutional amendment has amended the fundamental rights. Okay, now what happens? First constitutional amendment that has been challenged in the very famous case, that is Sankri Prasad versus Union of India in 1951. Sankri Prasad versus Union of India. Union of India, 1951. Here what happens? Here I had already told you that debatable word was the law in the Article 13 clause 2. The root of the problem was the word law in the Article 13 clause 2. Now what happens in the Sankri Prasad case? The debate reaches to the word law. The word law which is mentioned in the Article 13 clause 2, what that means? Here this judgment states that the word law means Parliament has the power to make the laws. Now this power can be enjoyed by the Parliament by two capacities: by ordinary legislative power, by which the government can make, Parliament makes the law by the simple majority. ठीक है, तो हम लोग इसको कहते हैं ऑर्डिनरी लेजिस्लेटिव पावर, बाय विच ordinary law was framed. Ordinary law, this is by the simple majority. And the other power Parliament enjoys, that is constitute power to amend the constitution. Constitute power to amend the constitution. To amend the constitution. That is Article 368. So what happens? The Sankri Prasad versus Union of India, in this judgment, Supreme Court says that Parliament enjoys two types of power of making the law. That is, first one is ordinary legislative power, by which the Parliament makes the ordinary law. That is framed by the simple majority. But Parliament also has the constitute power to amend the constitution, which is already mentioned Article 368. ठीक है? Now by this capacity, the Parliament can also amend the constitution, even the Part 3. So this judgment had clearly stated that the word law here only contains the Parliament this power. It means if the Parliament makes the simple law that will infringe or takes away or abridges the fundamental right, then this law will be unconstitutional or null and void. But this capacity by which the Parliament bring the constitutional amendment act, it doesn't mean this part. So the law word means this one only. It is outside of the word law. Means the debate has settled at this juncture, clearly states that by bringing the constitutional amendment act according to the Article 368, the government can amend the constitution means it also can amend the fundamental rights also. So this debate has reached that the word law in the Article 13 clause 2 means only the ordinary law. So means Parliament by framing the ordinary law cannot snatch the fundamental rights or bring or amend the fundamental rights. Parliament can do this only by the Constitutional Amendment Act. The Parliament can amend the constitutional any part or even the part 3, that is the fundamental rights. So the debate has settled here. Now what happens? It gives the license to Parliament to amend any part of the Constitution. So this judgment gave the license to Parliament to amend any part of the Constitution. Now what happens? We will move further. Now what happens? This story continue up to the Sajjan Singh. This story continue up to the Sajjan Singh versus state of Rajasthan. Sajjan Singh versus state of Rajasthan, that is the 1965. Now what happens? In this judgment, the 7th Constitutional Amendment Act has been challenged. Now what happens? The Supreme Court follows the same path which was mentioned in the Shankari Prasad case. So here you will not find any new things. The debate is same. The 7th Constitutional Amendment Act has been challenged, which amends some part of the part 3 or violation of the fundamental rights. It has been challenged in the Sajjan Singh versus state of Rajasthan, but in this judgment also the Supreme Court takes the same opinion as it had taken in the Shankari Prasad. So the debate is the same. Here also the judgment clearly states that by bringing the ordinary law, Parliament cannot amend the fundamental rights or any part of the Constitution, but by bringing the Constitutional Amendment Act according to the Article 368, Parliament can amend the part of the Constitution or even the fundamental rights. But from here, after the 1965, the U-turn take place. After the 1965 in the Sajjan Singh versus state of Rajasthan, now the U-turn take place. What happens? Government brings the 17th Constitutional Amendment Act. What was the 17th Constitutional Amendment Act? In this Amendment Act, there were many state laws. There were many state laws which were put into this 9th schedule. Which were put into the 9th schedule. Which were put into the 9th schedule. Which were put into the 9th schedule by the 17th Constitutional Amendment Act. Many state laws which were put into the 9th schedule. So there was a law of the Punjab state also. There was a law of Punjab state also. This law related to the land reform. It has also been put into the 9th schedule. So one gentleman of the Punjab, his name was Golaknath. So one gentleman of Punjab, his name was Golaknath, had challenged this 17th Constitutional Amendment Act. One gentleman, Golaknath, had challenged the 17th Constitutional Amendment Act. Who was the Golaknath? Golaknath was a citizen of Punjab who had a very big farmland. So the government was trying to bring the ceiling on his land holdings. So he challenged the 17th Constitutional Amendment Act because this amendment brought the Punjab state law into the 9th schedule. And I had already told you the 9th schedule gives the immunity to the Parliament, because this law, if put in the 9th schedule, it is outside the purview of the judicial scrutiny. Now what happens? This law has been challenged, this amendment has been challenged in the Golaknath case, that is Golaknath versus state of Punjab. Golaknath versus State of Punjab. Here the U-turn has been taken place by the Supreme Court. What the Supreme Court had pronounced in this judgment? Now the Supreme Court take very harsh words in this judgment. What the Supreme Court says that the fundamental rights are transcendental and sacred in nature. The fundamental rights are transcendental and sacred in nature. The fundamental rights are transcendental and sacred in nature. So no one can amend the fundamental rights. Even the word law means that is ordinary making law power or the Constitutional Amendment Act. The word law here contains both power. So Parliament cannot amend the fundamental rights even by bringing the Constitutional Amendment Act. If you have to amend any part of the Constitution, that is only possible by reconvening the Constituent Assembly, which is not possible because the members of the Constituent Assembly, many members of the Constituent Assembly in the 1967 already had passed away. Because so it means that the amendment of the Constitution or the amendment of the fundamental rights is not possible because in the Golaknath case, the Supreme Court had clearly mentioned that fundamental rights are transcendental and sacred in nature. No one can amend the fundamental rights. Even by the bringing the Constitutional Amendment Acts, the Parliament cannot amend the Constitution. So the word law, which was mentioned in the Article 13 Clause 2 here, which had two connotations, which means the ordinary legislative making power and the constituent power, that is to amend the Constitution, is same. This judgment creates this narration that fundamental rights cannot be amended, and it also gives a comment that the Article 368 is not the power of Parliament to amend the Constitution because it clearly states that it is a procedure to amend the Constitution. Article 368 is not the power, it is the procedure to amend the Constitution. So here the clear departure had been taken place by the Supreme Court from the earlier judgments. Okay, so here we stop and we will move further in the new lecture.